Thank you very much for the invitation to present at the academic conference on tax law organized by the Universidad de Concepción. It's a great honor to present here today, and I wish I could be in person, but of course that's the benefits of the technology. So my topic will focus on the use of predictive justice tools in the tax judiciary, in tax courtrooms. I will first explain what we mean by predictive justice and share with you some general considerations on the use of predictive justice, and then focus in the particular on the particular challenges that are raised by the use of predictive justice tools in the tax judiciary. So starting with what we mean by predictive justice, this is the deployment of natural language processing and artificial intelligence in judicial systems to predict the outcome of cases. So in my presentation and in my research, I generally adopt a more general idea and understanding of what we mean by predictive justice without limiting it to machine learning or artificial intelligence exclusively, but covering any type of language processing that can provide some prediction in the outcome of cases. The way these tools can be used can also vary. It can cover, as I said, prediction of the outcome of the case, or prediction of how an individual judge will vote, or whether a case should be heard or not prioritized or prioritized, and in general, how to optimize submissions and arguments before the courts, and including also evidence documents. So that there are many increasing benefits to using predictive justice tools, and these relate to efficiency and speed. And of course, more and more increasingly, courts around the world are very interested in these opportunities and benefits, considering the increasing workload and how this also affects the provision of justice. So there is a growing litigation around the world. So in this environment, providing these opportunities of efficiency and speed are very important. And then, of course, there are the benefits of predictability and consistency in the decision making. And we will see later on that there is the other side of the coin of consistency and predictability. But for the purposes of from the perspective of courts, this can give a lot of can provide a lot of certainty on the outcome of a specific case, especially when we're talking about very similar cases. So considering these opportunities, there are some general and ethical issues that are raised as a result. So the general question that, of course, arises is whether these models, these predictive justice tools actually work. And there is a lot of research, mainly from computer scientists, computer engineers, that are trying to use language processing and predict the accuracy of these tools. So there was a research publication by some computer scientist scholars that were trying to predict the outcome of the European Court of Human Rights judicial outcomes, and they managed to do it with an accuracy of 79%. However, they identify some problems and some challenges in this study. Apart from this, the challenges they identify, there are also shortcomings related to the use of data and whether the data they used to train the model were sufficient or whether they were representative. And there are also many limitations on how the machine, the model, can actually comprehend complex legal topics, complex legal issues. So these are the general questions that apply to any predictive justice model. And there is a lot of research and applications that are underway at the moment in order to improve the accuracy of these models. However, there are also some considerations, and the main consideration is whether actually the machine and AI can replace the human judges, and the underlying issue of that is whether they can replace the human judgment and reasoning. And the main considerations are because it's difficult to imagine that the machine can replicate the way judges perform. Judges are human emotional beings, and the way they provide their judgments is by using their intuition and conscience, and they actually function as a mediation between the abstract law and the specific facts of a specific case. So there is a general consideration that the algorithm cannot imitate this creative and interpretive activity of courts. So that also fits into the way that these models will be used, if used at all. The other consideration relates to whether deriving, of course, from the value of the human judgment and reasoning is, and this is the other side of the coin of consistency, is whether the algorithm is able to capture legal development and societal development, or whether using AI that is trained on past data will actually result in a conformism, judicial conformism, where the future judgments replicate past judgments without adjusting to new societal considerations. And all these considerations are also become worse, considering the black box problem. The black box problem describes the inability to have access to the way the machine and the tool reaches a specific conclusion. So we might have access to the training data and the output, but there's no transparency and accessibility to how the machine actually processes this data and reaches a specific conclusion. And this could be because there is inability to understand how the AI functions, and without necessarily meaning that we can never reach this knowledge, having access to this process. But there might be other considerations relating to intellectual property rights and the need to protect the intellectual property rights of those that develop a specific model. So this creates an additional hurdle, an additional barrier in accessing the way the model works. And as a result, the lack of transparency can also impact the trust that individuals, and in that case, litigant parties, have at the outcome of the case. And of course, trust in the judicial system is crucial in a democracy. So it can also affect the right of the litigant parties to defend and general fairness considerations with regards to how the justice system works. And of course, another challenge when we are talking about the black box problem, including the legal conformism consideration I referred to before, is that there is always a consideration that the data that were used to train the model have intrinsic intrinsic discriminatory and bias patterns that could, as a result, affect the outcome of the case. And these these considerations, seen in conjunction with the inaccessibility and lack of transparency of how the model works, increases considerations around inequality or whether the decision has intrinsic biases. So, so what has been done so far to provide a regulatory framework or safeguards against these challenges? The only document that could be directly relevant to this to predictive justice is the European Ethical Charter on the Use of Artificial Intelligence in Judicial Systems and Their Environment, and that was issued back in 2018. And as we can see, it outlines 5 principles. The first one is principle of respect for fundamental rights, principle of non-discrimination, principle of quality and security that has to do with the data and what data are used, how they are processed, and so on. Principle of transparency, impartiality, and fairness, and principle under user control, which relates to how humans are put on the loop and how they are involved in auditing the decisions that are made, and how the actors that are affected by the decision are informed and they have agency to have access to how the information, how the decision was reached, and as a result to defend themselves. So as we can see, most of these considerations outlined before are addressed by these 5 principles. But of course, this is a soft law document, and there is a lot of work to be done at the level of domestic law that has not been done yet. Coming to the tax space, there is very limited research on the issue of using predictive justice tools in tax. There is a lot of research covering the use of AI tools by tax in tax administration, and that's because, of course, many tax administrations are already using these predictive tools, and some countries have issued again some regulatory frameworks or some high-level guidelines, and as a result, this has triggered research and literature on this area. Here, I decided to just make a reference to a publication by Blank and Ozovsky in 2020 on automated legal guidance. And the reason for that is because I wanted to share with you the concept that these authors coined in the context of this publication, the concept of simplexity. So in this publication, the authors were looking at virtual assistants used by the IRS, which is the US tax authority, and they are examining benefits and risks. And their main consideration was that the use of these AI tools creates the impression that tax law is much simpler than it actually is. And that perception is created because the response to the taxpayer's question is very immediate, and also it seems that it's directed to the specific taxpayer. So it gives the impression that the machine is producing a tailor-made answer for this specific question, and creates a confusion that this answer can be relied upon. So their approach and their suggestion is that there should be very specific human oversight and review of these decisions, and also that if a taxpayer follows a specific course of action as a result of advice given by these virtual machines, virtual assistants, then they shouldn't be held reliable for these actions. So going back to the specific challenges for using of predictive justice tools in tax cases, there is a main consideration that has to do with information and power asymmetries. And I will explain what this means in the context of tax cases. So when there is a tax dispute before a court, one litigant party is always a tax authority and the other is a taxpayer. So in this scenario, in this context, the tax authorities are always the one litigant party, whereas taxpayers are different depending on the case. And what this means is that the tax authorities have a more access to information and more power in dealing with the tax cases compared to individual taxpayers. And the access to information concerns not only access to court decisions, but also access to current tax disputes that are have not been judged yet by the courts, but also access to other non-disclosable documents, including contracts, tax rulings, tax returns, and these documents, when they refer to other taxpayers and other tax cases, are not accessible by the taxpayer concerned in the specific case. So on the other side, taxpayers have limited access to all these documents, and sometimes they also have limited access to case law, and I will clarify what I mean by that in the following slide. So what this means in practice, what could this mean in practice is that if the tax authorities are using undisclosed tax data to train AI tools, and these AI tools make decisions on, for example, which taxpayers will be audited based on some risk factors, then taxpayers are unable to access this information because they don't have access to this data. Plus, they don't have access to the AI tool that is used, and as a result, there is an increased challenge that there will be entrenched biases that the taxpayer does not have access to and cannot defend themselves against these biases. The access to case law argument is also very important because not every jurisdiction provides full disclosure of its case law. There is a study by the European Case Law Identifier, and different countries, as you can see, the focus of this study was on EU jurisdictions, EU countries. And as you can see, every country has a very different legal framework on the publication of case law. So in Germany, there is no centralized database. A small percentage of case law is made available, and the criteria under which this decision is made are not known. In Poland, all decisions are published in a redacted form. Sweden, Finland, they don't publish first instance cases. In Spain, they also have a selection publication policy. Denmark, mandatory publication of all decisions in a centralized database. So with regards to these jurisdictions that all case law is published, then equally taxpayers have access to this, and this could provide a playing field for both litigant parties. But there are many jurisdictions that they don't have a centralized database, they don't publish all case law, and as a result, this creates an information asymmetry between the two litigant parties. So this information asymmetry and in conjunction with the use of AI tools by the tax authorities creates many challenges, potential challenges to taxpayers' fundamental rights. One main challenge is privacy and confidentiality, because, of course, there is this general understanding that tax data are confidential, even though there is an increasing interest in disclosing tax data, at least with some specific criterion parameters. But of course, the confidentiality relates also to trade secrets. So some tax data could be closely related to trade secrets, and disclosing these might put in danger and risk these trade secrets. So there is this argument of how we treat tax data for the purposes of training AI tools in a predictive justice context. And if we want all parties to function in a level playing field, whether it's possible or not to disclose all this data to all litigant parties, including taxpayers and not just tax authorities. There is also the challenge of discrimination and bias, and this is something I explained before in the general ethical and ethical issues, which relates to the black box problem. So if there is no access to the training data that tax authorities use to train the AI tools, so and also to the way the AI tools are functioning as the algorithms are reaching their conclusion. So there is a higher risk that there might be entrenched biases in how decisions are made. This of course affects procedural justice, because if taxpayers do not have access to this information, they are not able to challenge this information. And that has also repercussions for the rule of law. And final consideration is transparency, accountability. Again, it relates to having access to the information provided to train the AI, but also the way the AI reaches a specific outcome. And if that is not accessible, then there is a problem of accountability, especially in cases where there is no human oversight or there is very limited human oversight. So in that scenario, there is a question of who is accountable for this specific outcome, and whether those involved in the development of a specific AI model should also be held accountable. And I would also like to add some specific, some very special issues for the use of predictive justice in tax that are stemming. Some of them are stemming from all these challenges to taxpayers' fundamental rights that I have already mentioned. So the first consideration is that there might be an increasing risk in using AI in the tax judiciary, because tax disputes, it could be argued that tax disputes are more amenable to the adoption of AI, at least some tax disputes. And the reason for that is that it could be argued that some tax disputes are less sensitive compared to, for example, criminal cases, and also that some tax disputes rely more on numeric and logic-based accounting rules rather than judgments about the application interpretation of a specific provision. But I would like also to highlight here that this is relevant for some tax disputes, and not all tax disputes that require interpretation and judgment of and have a high subjective element. The second consideration that makes use of predictive justice in tax more special than in other areas of law is that there is a risk of cross-institutional bias transmission. By that I mean that predictive tools are used extensively in tax administration at the moment, So unless there is very strict regulation and supervision of these tools used in tax administration, there is a risk that the decisions made at the level of tax administration will also extend their impact on at the level of the tax judiciary. So if there is bias or discriminatory patterns in the decisions made by tax administration using AI, then this will also be extended to the tax judiciary. And the more the tax judiciary relies on decisions made by tax administration that are relying on the use of AI, then the risk of transmission of bias is becoming even worse. The third consideration is that, on the one hand, there is a need for more transparency to understand how the decision was reached, and that transparency could involve both taxpayer data, but also information about risk factors used by the tax administration to target some activities, and also the use of a specific AI model. But in that scenario, even though there is a need for transparency, there is a risk for manipulation of this information, and there is an increasing risk in tax cases, because if taxpayers are aware of the risk factors used by the tax authorities to target some activities, then they might be able to fly under the radar of the tax auditor and avoid being caught by the AI. So there needs to be a balance between transparency and the risk of manipulation. The other element that is somewhat contrary to what I first mentioned is that there is an increasing appetite and trend in domestic tax provisions, but also international tax provisions. And the previous presentation, it provides a very stark example of that, of case-by-case assessment and subjectivity in tax cases. So in some tax disputes might be more amenable to a logic-based assessment, and there's no need for interpretation of the tax provision. However, most tax provisions, especially those relating to anti-abuse provisions, require a high level of subjectivity, and which, of course, is connected to the value of human judgment. Of course, that consideration could be addressed by providing that any disputes that concern abusive behavior should be judged by human judges with no involvement of AI tools. However, that might not be able to be addressed or predetermined in all cases. And the final consideration is that there needs to be specific consideration of cross-border cases where, for example, we are dealing with taxpayers that have cross-border activities, and that could involve either a specific domestic provision, or it could also involve the application of a tax treaty. So in that scenario, tax authorities interpret the law in a way that could expand the territorial scope of the tax jurisdiction of a specific state. And so the involvement of AI tools in these cases where there is a cross-border element also involves these considerations of how the state interprets and applies the scope of its tax jurisdiction against other states. I would now like to give you an example of a jurisdiction that is already using a lot of AI tools, but also technology tools, not just AI. And this is also close to Brazil is South in Latin American countries. So you might be able to find draw some parallels with your system, or maybe not, depending on the similarities. So Brazil is a very good example of a complex federal tiered judicial system, which as a result creates a significant backlog of cases. This figure, 81.4 million cases, might not be accurate at the moment, so this figure might be higher, but it provides indication of the number of cases now pending before the Brazilian courts. As a result, Brazilian courts have already introduced many tools to address these challenges. 66 AI systems are in operation, and they are used by at least 50% of Brazilian courts. And these do not only involve AI-based tools, but also machine learning and other types of technology tools for classification of cases. Some examples are the following. So there is a system called Victor, used by the Supreme Court, and Ethos, used by the Superior Court, and both of these tools identify precedents that can be replicated in other cases. So the idea is to minimize the number of cases brought before these courts. And as you can see, there are other systems. For example, Savia is used by the Court of Justice of Minas Gerais state, and this is an artificial intelligence virtual assistant that's used by the personnel in the courts, and it's using a ChatGPT based system. In Brazil, currently, there is no specific system addressing and regulating the use of predictive tools in the judicial system. There was a resolution by the National Council of Justice in 2020 that was actually influenced by the European Ethical Charter mentioned before, and repeating most of the principles. And then more lately, we have the 2023 bill on AI, and there was a reference on the use of AI for the administration of justice to clarify that this is a high-risk system. So specific considerations on transparency and accountability should be taken into account. And here are the articles of this resolution of the National Council, where, as I said, they more or less replicate what the European Ethical Charter is providing for. So why I bring Brazil as an example? The reason is that Brazil, as I said, has a particularly significant problem with the backlog of cases. That is because of the complexity of its legal and judicial system. So that's one of the reasons why Brazil has also started introducing, since many years now, technology in the provision of justice. But also there are specific risks that make Brazil a very interesting example for a case study. And that these specific considerations have to do with efficiency, specificities, but also judicial independence concerns. And there were some cases where arguments can be made that judges are not independent, so that could potentially make the use of AI tools more appealing. The same for corruption considerations and inequality concerns. So for other jurisdictions as well that share these concerns, the use of AI tools has special risks or special opportunities. And in this context, it is a bit discouraging that the international AI governance frameworks are mostly developed by developed countries to accommodate their needs instead of focusing also on specific needs and risks raised in these emerging economies. So just to finish with some ideas of how we could, what could be an appropriate framework to accommodate all these risks and challenges. There are three areas of focus that this framework could look into. The first is the intent purpose of the use of predictive justice tools in the tax judiciary. The second is the scope. The third is some more specific safeguards. Intended purpose could vary from using this tool to minimize the number of cases, or as a tool to prioritize cases, or even as an assistance to the work of judges. With respect to the scope, it could either cover all cases or focus on some lower tier or first instance court cases, put a threshold, and that could also exclude cases where more judgment and subjective assessment is required. And in terms of safeguards, that in the case of tax, that could involve, for example, the publication of all tax court decisions, which is not the case for, as we saw, some jurisdictions, at least in the EU, and that could be done in the form of in a redacted form, or providing free access to case law databases, and of course introducing a human review, having the human on the loop, and that could be done in different phases to guarantee that there is enough supervision. And of course, acknowledging that there must be a different procedure for appealing these cases if an AI system was involved. And some final considerations could be for safeguards, could be also registering the algorithm used in the judicial system in the public register, so everyone has access to the tools used, and also allowing more flexible access to the use of intellectual property relating to technology used in the judiciary. So that was my presentation. Thank you very much for your attention, and I hope this presentation gave you some more information on this topic and some inspiration for further research or further policy work. Thank you very much. Thank you very much. We look forward to more collaboration opportunities. That was great.